Thank you, Mr. Chairman. Very briefly, I think there's no way to follow that, but there's certainly bipartisan support for this, and I hope we can restore this. It's been around since 1983. In fact, I was wondering if Ms. Roybal Allard's father was the one who inserted the provision in the first place to begin with, a long time ago when he was chairman of the committee. But it's something that you've heard from everybody on, and I would just hope that we pass it and pass it unanimously. Thank you.
Question is on the Serrano amendment. All in favor say aye.
Aye.
All opposed say no. No. The ayes have it. The amendment is agreed to. Are there other amendments? Mr. Yoder. Clerk will read.
Which amendment?
Which one?
Amendment offered by Mr. Yoder.
Without objection, the reading is dispensed with.
Thank you, Mr. Chairman. This amendment we addressed last year in this committee on this bill as well. This amendment deals with the privacy of our digital correspondence and stored information in this country. We all remember the NSA situation, and we're still uncovering and going through how we examine what the NSA is doing to our private information. Much of that dealt with metadata. The big issue there was partly phone records of Americans that the federal government was containing. This issue, frankly, that we're addressing here is much more egregious abuse of our civil liberties and more egregious abuse of the Constitution. Many of our civil agencies, such as the SEC, the IRS, Department of Justice, and other agencies, are using a 1986 law that is out of date and out of touch with the ways Americans store and communicate today. This 1986 law essentially says that when information is stored over 180 days on any type of server, it is considered abandoned by the user and therefore searchable and seizable by the federal government without a warrant, without due process, without probable cause. There is a bill going through Congress. It's called the Email Privacy Act. It has 220 co-sponsors. Many in this committee are co-sponsors. It's a bipartisan bill. One of my co-sponsors is Jared Polis. The other one's Tom Graves. And so we certainly have support all across the conference. And what this amendment would do would be to prohibit funding for searches and seizures of digital correspondence without following the normal warrant procedures that we'd use for paper correspondence. Probably one of the most frustrating responses regarding this issue when it was raised in the last year was the IRS's position that they had previously held, and I don't know that they hold it today, but who knows what goes on over there half the time. The IRS's position was that Americans have no expectation of privacy when it comes to their email accounts. Well, frankly, I disagree, and I think many of you disagree, and I think most of your constituents would disagree. Americans do expect that when they correspond to one another, that digital correspondence is treated just like paper correspondence, just like mail that goes through the Postal Service 6 days a week. So this amendment would prohibit funding for utilizing that 1986 law in a way in which it would violate Americans' Fourth Amendment rights. It would require that the Fourth Amendment be followed, that a warrant be utilized to examine stored information. This is not only an issue for our constituents, not only an issue for the individual liberty and privacy of our constituents, it's also an American business issue. I had a chance to visit with many of our technology companies and some of their CEOs that store lots of information. They're telling me some of the main questions they get when they're overseas or when they're dealing with foreign investors or foreign individuals is, if I store my information on Google or on Dropbox or one of your companies, does that information then become searchable and seizable by the federal government? Because if so, I don't want to store information with American companies. They say they don't want to use domestic technology companies. This is going to be a jobs issue. It's a Fourth Amendment issue for sure, and it's one that I think we can come together on as a Congress and fix this session with legislation. But this amendment would prohibit funding with the entities that are in financial services if we can't get that bill actually passed. It's supported by the Heritage Foundation, the ACLU. I mean, we're bringing the world together with this legislation. And so I hope that this committee could support this as we did last year. And with that, Mr. Chairman, I yield back the balance of my time.
Chairman Crenshaw.
Thank you, Mr. Chairman. I rise in support of this amendment. I want to thank Mr. Yoder for his hard work on this issue. I think most of us believe that the agencies funded in this bill should not be able to look at Americans' old emails without a court order. So I urge the adoption of this amendment.
Mr. Serrano.
The love fest continues. I rise in support of the gentleman's amendment. I'm glad my primary was yesterday and not tomorrow by saying that. I'm only kidding. This amendment This amendment bars agencies government-wide from accessing private electronic communications held by third parties unless the appropriate constitutional standard is met or warrant based on probable cause. And I just want to briefly say that the reason that this has bipartisan support is because, in spite of what some people may think, we on both sides do not like this kind of behavior, and we feel that constitutionally we have the right to privacy. And so rather than go through all the various points that the chairman, that the gentleman has made about his amendment, I support it. I hope we support it in a bipartisan fashion, and I hope that we send a message with it that, notwithstanding what some people think, we all in this House value our privacy and value our Constitution and value the proper behavior in dealing with these issues. And I yield back.
Mr. Fatah.
Mr. Chairman, I rise in enthusiastic support of my colleague's amendment, and I'm also a co-sponsor of the principal legislation that he referred to. I think this is extraordinarily important, that we draw a line. It has nothing to do with political philosophies or anything of the sort. It goes to the constitutional protections that we have as in terms of privacy and due process. So I strongly encourage the committee to adopt the amendment.
If there's no further debate, Mr. Yoder is recognized to close.
I want to thank my colleagues on the other side of the aisle and my colleagues here as well, and the chairman for their enthusiastic support. This is an issue I think we need to get accomplished this session. If you haven't signed on to the underlying bill, just to put in a plug, Mr. Chairman, H.R. 1852, we'd love to get your co-sponsorship. And with that, Mr. Chairman, I'll yield back the balance of my time.
Question is on the Yoder amendment. All in favor say aye.
Aye.
All opposed say no. The ayes have it. The amendment is agreed to. Mr. Serrano,
Mr. Chairman, I have an amendment at the desk.
clerk will read.